Good morning, everyone. Welcome to the Kansas Court of Appeals. My name is Henry Green. I will be the presiding judge this morning. The judges are Catherine Gardner and Rachel Pickering. I apologize for the late start that we got, and also apologize to appellant's attorney having to drive all the way from Liberal to participate in Zoom arguments, but the Zoom situation came up at a late time for us. And again, I apologize. Our case this morning is Diana Lopez, and she is an appellee versus a National Beef Packing and Zurich American Insurance Company. They are the appellants. This case has been set for 20 minutes, and I need to get their appearances. Appearing for the appellee. Is it Mr. Cooper?
It is, Your Honor. Jeff Cooper on behalf of the appellee.
Thank you. And appearing for the appellants.
Yes, Your Honor. Shirley McQueen, appearing on behalf of National Beef Packing Company and its insurance carrier.
As I indicated, this case is set for 20 minutes. Ms. McQueen, do you want to have any rebuttal time? Did you want to kind
Yes,
of...
yes, Your Honor. If you could give me 3 minutes for rebuttal.
3 minutes, okay. And I have you for 17 minutes for your main argument. Are you ready to proceed with your argument?
I am, Your Honor. Thank you.
Okay, we ready to hear that? Thank you.
Thank you. May it please the court. National Beef is asking this court to find that there was not substantial competent evidence to support the June 28th, 2023 order of the appeals board, and also that the board misinterpreted and misapplied existing law. To set the stage, Ms. Lopez was at all relevant times a fabrication supervisor at National Beef. Her job was not repetitive. It did not require lifting of weights or pushing or pulling. She was charged with doing supervisory things, handing out personal protective equipment, attending morning meetings, keeping a calendar, generally making sure that her subordinate employees were operating safely. However, on or about December 20th of 2019, one of Ms. Lopez's subordinate employees went on vacation. And in this employee's absence, she stepped in to do the job of the employee's job, which was boning brisket. And that job was a repetitive job. And by her account, Ms. Lopez did this job for roughly 2 weeks. So with that stage being set, Ms. Lopez has claimed work-related injuries involving myofascial changes and a torn rotator cuff. She gave National Beef notice that she was claiming a work-related event on January 22nd of 2020. And from that date until about 17 months later, in June of 2021, when Ms. Lopez saw the court-ordered independent medical examiner, Dr. Carabetta, she consistently alleged that she was entitled to benefits due to the repetitive nature of her job as boning brisket for this 2-week period of time. Upon receipt of notice, National referred Ms. Lopez to Dr. Hufford for examination, and Dr. Hufford found that the repetitive work that Ms. Lopez had done for that fairly short time frame was not the prevailing factor in her medical condition. And of course, one of the requirements to qualify for benefits under the Workers' Compensation Act is that your injury has to have arisen out of and in the course of employment. And one of those elements is that the work that you've done has to be the prevailing factor in your medical condition. So Dr. Hufford found that it was not. It's also, I think, important for this court to consider that even before Ms. Lopez went to see Dr. Hufford on January 14th of 2020, she met with Danny Briggs, who's National Beef's physician's assistant. And during that meeting, she denied to Mr. Briggs that she'd suffered any work-related injury or accident. And so then we fast forward to June of 2021 when she saw Dr. Carabetta, and he likewise found that the repetitive work of such a short duration was not have or would not have caused the torn rotator cuff. So he said the repetitive nature of boning brisket was not the prevailing factor. This, in a nutshell, is what the prevailing or what the substantial competent evidence is. And it absolutely mandates a finding that she failed to move her burden, failed to meet her burden of proving injury by repetitive trauma. But where the case took a bit of a swerve is when Ms. Lopez saw Dr. Carabetta, again, 17 months after reporting an injury by repetitive trauma to National Beef. Ms. Lopez told Dr. Carabetta that she remembered a very specific event, and that was on January 2nd of 2020, when she reported that she felt a pop in her shoulder while working on natural beef, which she represented as involving significantly more force than does boning beef that is not natural or beef with hormones. And Dr. Carabetta opined that this pop was probably the tearing of her rotator cuff and that her injury was not caused by repetitive trauma, but it was caused by accident, which is, of course, distinguishable. Now, this is not a situation where Ms. Lopez may not have realized that she felt the pop until sometime after, because she testified during her deposition or the regular hearing testimony, which was taken by deposition, that she remembered feeling the pop in her shoulder on January 2nd of 2020. But what the record reflects, and it reflects this by Ms. Lopez's own testimony, is that she never told anybody about the pop. And the alleged difficulties in boning the natural brisket. What the record reflects is that she did not tell her supervisor that she felt a pop on January 2nd, 2020. She did not tell the emergency department physician about the pop when she saw him on January 3rd of 2020. So the day after this alleged pop, she's not told her supervisor, she's not told her ER physician. I'm sorry, did I start to interrupt somebody? Okay. Again, she saw Ms. Briggs Mr. Briggs on January 14th of 2020, which was 12 days after this traumatic event or the alleged traumatic event. And at that time, she knew she had a torn rotator cuff. She'd had the MRI. We had the results. She and Mr. Briggs discussed the torn rotator cuff. But again, she specifically denied any accident or injury at work. She told Dr. Desai that she had an onset of pain in her right shoulder 2 weeks prior to January 3rd. She told Dr. Hufford that there was a reporting date of pain on December 20th of 2019. She did not tell Dr. Marotti that she'd experienced popping in her shoulder. In fact, she told Dr. Marotti that she'd injured her shoulder through repetitive work. So for 17 months, this was the claim that National Beef was defending. And while National and 2 out of 3 physicians did not believe that the repetitive work was the prevailing factor in the torn rotator cuff, at least Ms. Lopez's recitations were consistent until 17 months later. And following her appointment with Dr. Carabetta, Ms. Lopez's explanation as to why she'd not told anybody about the pop that she felt in her shoulder on January 2nd was that no doctor had specifically asked her. Now, Dr. Hufford did testify that his practice is to ask his examinees about any specific event. And if the examinee relates the occurrence of an acute traumatic event, he would have referenced it in his report, and it's not there. But ultimately, doctors are entitled to rely on the information their patients give them. And likewise, National Beef was entitled to rely on what Ms. Lopez had told them for 17 months. But in addition to the fact that Ms. Lopez completely revamped her mechanism of injury 17 months after it was first reported, her explanation as to what led up to the alleged pop in her shoulder has no relationship to how the job of boning brisket is done.
Counsel,
yes.
Before you get into that, could you clarify for me how specific the notice needs to be under the work comp statute? Because you concede she did give timely notice of the repetitive injury, but not of the pop. So that's why I'm asking.
Okay. And, Your Honor, it's not been forever that the Workers' Compensation Act distinguished between injuries by repetitive trauma and injuries by accident. And it is the position of National Beef that if we knew of the specific mechanism, that we need to have knowledge of the specific mechanism of injury, because that becomes important in some of the other issues that we're going to bring up, specifically the issue of whether or not National Beef has an obligation to reimburse the claimant for all of the medical treatment that she has received.
So it's a matter of more of a practicality than of the language of the statute.
As to some of the issues, but I think ultimately the whole intent of the notice statute is to give the employer an opportunity to investigate what happened. And we were investigating a repetitive use injury. And that's what we investigated because that's what we were told about. I can't obviously speak for all employers, but I think that for the most part, employers try to do the right thing by their attorneys, by their employees. And if we're told this is a repetitive use injury and the doctors say that would not have caused it, then to allow the employer or the employee to come up 17 months later and say, well, it really wasn't that, it was this other reason, really makes it very difficult for employers to do the right thing and to move forward. And it exposes them to a lot of liability that may not have been there had they had notice.
Thank you.
You're welcome. So again, there's no difference between boning natural beef and boning processed beef. CO2 is injected into the seams of both. Natural brisket is not larger or heavier than brisket with hormones. It takes exactly the same amount of effort to bone natural beef than its counterpart.
Ms. McQueen, can I interrupt you for a moment?
Of course.
Was this Miss Lopez's theory? Was she the only one who theorized that there was a difference between the two types of brisket?
She is the only one who testified that there was a difference between the two types of brisket. And that I will concede that this may be a more difficult sell for National Beef, just because I know it's not this court's function to reweigh the evidence, and our standard is pretty high with substantial competent evidence. And what the board said was there are disagreements as to how physical the job of boning brisket was. But what National would say in response to that is, in this case, there was testimony by two management level employees whose job it was to understand the physical stressors of that job. And then there was Ms. Lopez, whose testimony now has sort of changed, throughout. We go from repetitive use of boning brisket in general to on this particular day, for this particular number of hours, I was dealing with a harder job. And we believe the substantial competent evidence is that it was not any harder.
Can I move your argument, if you don't mind? I'm looking at page 20 to 23 of your brief, where you review the facts that the board puts together that you're saying these don't follow what the record states. Could you outline that argument a bit? Because that would help us understand your argument about substantial competent evidence is not met here.
Certainly. You said 20 to 23 of my brief?
Right, where you're explaining what the board says in their order doesn't comply with the facts of this case, the record. And I'm specifically starting with the appellate board made some specific findings, first sentence of your last paragraph, that were not borne out by the record. Could you expand on that or help us understand that, please?
I could if I was actually paying attention to the page numbers. You said 20 to 23. Okay.
I don't mean to throw you off, but
no.
Just in general, it's the bottom of page 20 of your brief, but it's really just if you could explain your argument that the board's findings do not mirror what is present in the record.
Well, the board did, and yes, thank you for giving me the time to sort of process that. The board made certain findings that they seemed to reflect were supportive of their decision that just are not in the record. For instance, they said that Mr. Briggs denied the fact that there was a torn rotator cuff. He never denied that there was a torn rotator cuff. He discussed with Ms. Lopez that, in fact, she did have a torn rotator cuff. What he denied, or what National denied, was whether that torn rotator cuff was caused by her work. So when the board says that Mr. In a way, the way that we interpreted the board's decision was that they were attempting to discount Mr. Briggs's and National's position in this matter by saying that Mr. Briggs was denying what objectively was the case, and that is that Ms. Lopez had a torn rotator cuff. That's not what he denied. The board also said that the physicians that the evidence submitted that the claimant, that two medical experts found that the claimant's job for 2 weeks being repetitive was sufficient to cause her injuries. That's not what the record was, at least insofar as the rotator cuff. Now, one of the doctors or two of the doctors did say that the repetitive use would have caused the myofascial changes. But when we're talking about the rotator cuff, 2 of the 3 physicians specifically said that 2 weeks worth of repetitive work would not have caused the rotator cuff. So,
excuse me, Ms. Queen, you got 2 minutes before you get into your rebuttal time. And while I'm interrupting you, the independent medical examiner, he gets back that the board does admit that this evidence was conflicting, but the independent medical examiner says that this injury, this rotator cuff, occurred while she was deboning. I mean, this is a testimony, and we have the board saying we give more credit to his testimony than the other 2 doctors. How are we supposed to deal with that?
Okay, so Dr. Carabetta did say that, or did offer his opinion that the event of January 2nd of 2020, where Ms. Lopez now said she was boning a tougher, all-natural brisket, would have been sufficient to have caused the torn rotator cuff. But in order for the board to have made the finding that it made, and in order for this court to affirm that finding, this court is going to have to ignore 17 months worth of recitations by the claimant that this was a repetitive use injury, because it is a distinction that needs to be made between an injury by repetitive trauma and an injury by accident. And 17 months after Ms. Lopez reported her injury to National Beef, she changed the entire mechanism of it. She had absolutely neglected or refused to tell any of the healthcare providers that she had felt a pop. And so the court's going to have to disregard all of those inconsistencies and a 17 months worth of history from Ms. Lopez in order to get to the fact that now, 17 months later, this is the true story. And in fact, the administrative law judge who initially ruled on this, he said, there's not a preponderance of the evidence to establish her entitlement to an award. Her story changed, and it changed significantly. And for that reason, the administrative law judge denied compensation to the shoulder. And we would argue that that is where the substantial competent evidence falls, and not the decision of the board in regard to that.
Thank you. Do you want to keep your rebuttal time?
Give me just a second to sort of wrap up these points. Clearly, there are other issues. One of which involves the reimbursement of medical the reimbursement of medical payment that the claimant made on her own, that I alluded to briefly in response to Judge Gardner's questions. The employer is always responsible for providing medical treatment, reasonable medical treatment. And if the employer doesn't do so, the claimant can go and get her own medical treatment, and then the employer still is responsible for paying for it. And it's on this basis, presumably, that the appeals board ordered National to reimburse the claimant for authorized medical treatment. But please keep in mind that when National Beef denied medical treatment, National's decision was reasonable under the facts that they had at that time, which was 17 months worth of doctors saying this was not caused by repetitive use. So National denied medical treatment on that basis. And 17 months later, when some doctor decides that it wasn't a repetitive use claim, as has been pled, but that it instead was an injury by accident, by traumatic accident, it is not consistent with the intent or the actual stated language of the statute that National should be penalized by having to go back and reimburse the claimant for all of the medical treatment she obtained on her own. Finally, we have addressed a legal issue involving the timeliness of the notice. We would just stand by our brief in that regard. And I appreciate your time and your questions.
Thank you. I appreciate it. You still have your 3 minutes rebuttal time. Mr. Cooper.
Thank you, Your Honor. Claimant contends that the board's findings are supported by substantial competent evidence, and that the board correctly interpreted the law and should be affirmed in all respects. Claimant respectfully requests this Court of Appeals affirm the appeals board decision of June 28, 23. The claimant was employed by National Beef in a fabrication job, and basically that's a supervisory job where she basically makes sure they have enough people to do the job and to work, etc. There's quite a bit of testimony about that, and I'm not going to go all through that, but occasionally she does have to fill in at various positions when employees are gone, and that's what she was doing between December 20 of 2019 and January 3. She was working on a line deboning briskets. Claimant testified, and I think the rest of the evidence clearly shows that it's significantly more physical job than what she did as a supervisor. I think there's some testimony that kind of average. She was deboning with a knife, and she testified about how physical that was with a hook and a knife. She handled 785 briskets a day based on just a division of the 4 people doing the number of briskets that went through. She had the hook in her left hand and knife in her right, and she would push and pull. There was dispute as to what the briskets weighed, but they were heavy, and she's pulling and tugging, and doing that for 2 weeks, 4 to 8 hours a day on the briskets. She testified, and claimants testified in this case, and I believe she's entirely credible. All of the people that testified in her regard, including her supervisor, testified she was honest and trustworthy and worked in this job for several years. But as May, she started having problems in her right upper extremity, right chest, right shoulder. She reported that to her boss on January 3, 2020, but she's not a doctor, and she said she was having pain and problems in her breast. So she went to the ER and got a work release note. She's having problems with her right upper extremity. Those restrictions from, let me back up. She went to her PCP January 6th, and those notes were given to Danny Briggs, who's the physician assistant at National Beef. There's some controversy over what was said between my client and Mr. Briggs. My client says he told her there's no way this happened at work, and we're not providing any treatment for you. Consequently, she goes to her PCP. PCP ordered an MRI, and she has a torn rotator cuff. That information was all presented to Danny Briggs and IBP, and they basically said, we don't think this is a work-related injury, and therefore we're not providing any treatment for you. There's ample evidence of notice of injury that was given to IBP, and they chose not to provide any care and treatment for her testimony about what Briggs told her, that she had a torn rotator cuff, but it didn't happen at work. That's all in the record, and I know you'll review that.
Mr. Cooper?
Yes.
Let me ask you the same question I asked opposing counsel about the notice. Is it your position that the work comp statute only requires the employee to give notice to the employer of a work-related injury? Nothing
I believe
specific?
that's what the cases I think cited in our brief all say, that notice of an injury, as long as they've got sufficient information to determine that there's been a work-related injury, that's sufficient.
Thank you.
All right, thank you. There's controversy over what my client says she told our PA Briggs at the plant that she heard it at work. There's no evidence that she had any prior problems with those body parts. She'd never seen a doctor, never had any problems. She obviously knew something was wrong, but she's not a doctor, and the respondent's taking the position that, she needs to tell a doctor what doctors are supposed to find out. She's got pain, she's got problems, she's off work. The insurance company at some point sends her to Dr. Hufford, who notes that she has problems arising from her work after 2 weeks, but says that it's not work-related. She's then seen by Dr. Marati, and the court sent her at that point to Dr. Carabetta for a court-ordered independent medical evaluation. That's a procedure that the workers' compensation court uses to have a neutral party take a look at the facts, the evidence, evaluate the claimant. And Dr. Carabetta says that her problems are, from a prevailing factor standpoint, related to her work injury. He says that her neck and upper back, the myofascial pain is related to the repetitive trauma of the 2 weeks of deboning the beef. He then also says that she reported to him that she felt a pop, and he says that was the event that more likely than not, more probably true than not, caused a rotator cuff tear. That occurred while she was working. There's no dispute on that. The court-ordered doctor, Dr. Carabetta, says that the work injury is the prevailing factor. What happened to her at work is the prevailing factor. Dr. Marati, who was hired by the claimant, has the same opinion. And Dr. Carabetta had all her medical records, all her diagnostic tests, met with the claimant, and found that the work injury was the prevailing factor, both for the myofascial problems as well as the rotator cuff. He stated that there was no other possible cause for claimant's injuries. So
let me ask you this. Do you
Sure.
believe the independent medical examiner and Dr. Murata that what they diagnose has been, and I need you to point to it if it happened in this case, has been so undermined by that we should not give any basis for the board's decision?
Yeah, I don't think there's any evidence that supports that it's been undermined in any fashion. There are some very minor issues in terms of when something happened, but the doctors, Dr. Carabetta was deposed twice, and both times he stuck to his guns and said that the work injury is the prevailing factor, as did Dr. Marati. And that evidence, plus the claimant's testimony, which I believe is credible on the type of injury, et cetera, all support the decision of the appeals board. Primarily, the appeals board put more weight with Dr. Carabetta since he was court ordered. But we believe that looking at the evidence as a whole clearly supports the decision of the appeals board. We would urge the Court of Appeals to affirm that. I don't think the
can I interrupt you for a moment? I'm gonna did the board in their findings accurately reflect what is in the record?
I believe absolutely.
Question.
Absolutely, they did.
Okay, so could you respond to the arguments that the facts are not what they are in the board's final order?
Well, I'm not sure exactly what you're asking me, but I think respondent is alleging that since the board didn't put a lot of emphasis on the pop, they basically said the evidence from Dr. Carabetta, et cetera, showed that the prevailing factor for her work-related injury and the ultimate 13% impairment was directly related to her work injury. And there's no evidence to the contrary. There's no car wreck, there's no accident at home or any other evidence of anything other than her work activities that caused the resulting impairment she has. So based on that, I think that's a very strong indication that the appeals board was correct, that they reviewed all the evidence and come to the correct conclusion based on the entirety of the evidence, including, all the testimony that was taken in this case.
Thank you.
Does that
that answers my question?
All right, thank you. Dr. Carabetta was asked about the pop, and basically, as I understand his testimony, she was having problems for 2 weeks doing this physical job and pushing that one particular item caused the rotator cuff to tear. It also clearly indicates that the repetitive trauma affected the myofascial pain, and he rated both those conditions. So I don't think, respondent's position on notice is appropriate. They knew that she was having problems with her shoulder. She's not a medical doctor, and they had sufficient notice. The evidence from Dr. Carabetta, Dr. Marati, and her testimony is all consistent with a work-related injury. We believe the appeals board reached the correct conclusion. We would ask the Court of Appeals to affirm that decision in all respects. I'd be happy to answer any questions you may have. Thank you.
Are there any other questions from the panel? Thank you, Mr. Cooper.
Thank you.
Now, Ms. McQueen, we're ready for your 3 minutes rebuttal.
Thank you, Your Honors. On behalf of National Beef, I would state that, even if the court rejects National's argument that there was not timely notice. Well, let me back up and say, if the court finds that there's not timely notice, then Ms. Lopez is not entitled to compensation for her rotator cuff, period. But even if the court finds that notice of one thing constitutes notice for everything, the evidence that is substantial and competent still does not allow the finding of the appeals board to be confirmed. That this court, to make that finding, is going to have to, again, overlook 17 months of reports. This claimant saw Ms. Lopez saw Danny Briggs. She saw Dr. Hufford. She saw the emergency room physician. She saw Dr. Desai, who ended up being the operative surgeon. She saw Dr. Marati, and she saw Dr. Carabetta. And she told all of them that she injured her shoulder just doing repetitive work at National Beef for a 2-week period of time. And the neutral physician, who, sort of as a matter of practice, is generally afforded by administrative law judges more credibility than the physicians who have been retained by one side or the other. Dr. Carabetta said, as should be apparent to all concerned, her doing this job for 2 weeks would not have caused the torn rotator cuff. He makes it very clear that the injury she's complained about, with the mechanism of injury that she alleged, wasn't going to fly. And so then Dr. Carabetta asks some additional questions, maybe prompts the claimant further. And he says, wait a minute, now she tells me about a single traumatic event. She saw the emergency. It shouldn't matter that she's not a doctor or not, but she was in the emergency room the day after this traumatic event with discomfort, which she has testified and told the doctor she equated to breast pain with a lump in her breast. She never told the emergency room physician that she'd experienced a pop the day before. She didn't tell Danny Briggs. In fact, she specifically denied to Mr. Briggs on January 14th that she had had an injury at work. When we talk about whether or not the cross-examination or the other evidence is such that it undermines the board's finding, this is it exactly, because this court is going to have to ignore volumes of evidence and make a finding that, 17 months later, what she tells us now, or what she told the doctor 17 months later, That's the truth that we're going to go with. And we're going to ignore everything else.
Let me ask you a procedural question then about the board's findings, because when I think about the notice issue and I look at the board's findings, I really don't find any factual findings by the board about any notice issue. Can you point me to any?
No, there is none. And in fact, I raised that lack of finding in the brief. This was a somewhat procedurally unusual situation in that both Ms. Lopez and National Beef sought review from the administrative law judge's finding. Or his award. And the reason for that was the administrative law judge said the shoulder was compensable or was not compensable, but the myofascial changes were. So Ms. Lopez appealed the shoulder issue. We appealed the myofascial change issue. But because National had prevailed on the shoulder issue, the notice issue, or the lack of timely notice issue, wasn't an issue that we raised in our application for review. But we did brief it in response to the claimant's application for review, and the board was completely silent. So that's why we've raised it in front of this court. Now, Mr. Cooper, I believe, said in his response to our brief is that the board impliedly found that notice must have been given since they awarded compensation.
What do you think of that?
I'm sorry.
Do you agree with that?
I don't agree with that. I think that notice has to be specifically addressed, because if there was no appropriate notice, then there could not be compensation. Now, I do think that since that's an issue of law, I think that this court can make its own finding, but I've also said that, the court could also remand it back to the appeals board for that finding. But I think that issue has to be resolved either by this court or by the appeals board.
Thank you.
So, just to quickly sum up, the weight of the evidence just does not really establish that Ms. Lopez suffered that injury by accident, that by injury by trauma. And if she didn't, if the popping that she allegedly felt was some newly created explanation 17 months after the fact, because clearly had she not said, I felt a pop, if she wouldn't have told Dr. Carabetta that, she wouldn't have been awarded benefits to her shoulder, because none of the doctors believed that the repetitive use would have caused the rotator cuff tear. So it's National's position that that was some newly created mechanism of injury, because that's the only way we can rationalize it with the rest of the evidence. So we do believe that that sufficiently undermines the evidence relied upon by the board, and we're asking the court to overturn the decision. Thank you. Oh, and not on a substantive matter, thank you for your apology about turning this into a Zoom hearing. Things happen. It's not necessary. The apology is not necessary. I'm always happy to come to Topeka.
Oh, thank you. You make us feel somewhat better to have you to come in. We appreciate your argument, Ms. Queen, and Mr. Cooper's arguments. Very good arguments, and we will try to discuss this case. This is not an easy case, and get you an opinion as soon as possible. Again, thank you for your consideration with us.
Thank you.
Take care and have a good day.
Have a good one. Thanks.